In the absence of any problems of the types that we discussed previously, a valid contract will be formed. That means that the parties are bound by and have certain duties under their agreement. First and foremost, this includes the central duty to perform their obligations in good faith according to the terms of the contract. The details of performance and problems surrounding performance is what we'll look at in the following. As long as such performance occurs, there is no problem. Once both parties have fully performed under the contract has been discharged. For example, a buyer orders and pays for goods, and the seller delivers the goods within the agreed time frame. If that's the case, no more obligations are left under the contract, and it is discharged. But if performance is not according to the contractual terms, then there is a breach of contract. There are different types of contractual breaches. The most severe one is a material breach. A party has materially breached the contract if the party fails to perform a contract according to its essential terms. This includes non-performance of a service or failing to deliver a good after receiving payment. These things are clearly essential and go to the heart of a contract. A seller's most essential duty is to deliver a good or service, and a buyer's most essential duty is to pay for these goods or services. The most common consequence of a material breach is that it discharges the non-breaching party from its own obligations and provides grounds to sue for damages. Apart from a material breach, another possibility is that a party does not entirely, but almost entirely, performs its duties under a contract. That is, except for a few minor omissions or errors, there has been performance. The non-performance only extends to non-essential contractual terms. This is the concept of substantial performance or immaterial breach. In case of substantial performance or immaterial breach by one party, the non-breaching party must still perform their duty. That is, they must perform their part of the bargain, although they will be allowed to deduct the costs of curing the minor defects in the other party's performance. Let's look at an example of substantial performance. Taylor has agreed to make a black suit with black buttons for Dev. He accidentally puts on purple buttons instead of black buttons. The cost of replacing the buttons is $20. Can Dev avoid paying the tailor? The answer is that he cannot. Taylor's performance amounts to substantial performance or immaterial breach. Dev therefore still has to pay the tailor the full contract price, but he can deduct the minor cost of replacing the buttons. Yet another scenario is that of anticipatory breach. Anticipatory breach occurs when, before contract performance is due, one party tells the other party that they will not perform the contract. That is, the party shows its intention to breach the contract. This gives the non-breaching party two choices. First, the party can immediately treat the contract as having come to an end and sue for damages. Or second, the party can still wait and see if the breaching party will change its mind and perform. Let's look at an example of anticipatory breach. 2 weeks before Dev is scheduled to pick up the suit he ordered from the tailor, Dev tells Taylor that he won't pay for the suit. At this point, the tailor may either wait and do nothing, hoping that Dev will change his mind. Alternatively, the tailor may immediately sue Dev for damages, that is, his profit under the contract.